if you have a spouse and no will, do things go into probate? It depends. So first, let's look at what types of assets go through probate. If a person passes away and they own assets in their name only, so there's no joint ownership, and they also did not list either a beneficiary or a POD, payable on death, or TOD on these assets, or they don't have these assets in a trust, then those are assets that are eligible for probate. So it's basically things that are owned by you individually, not listing a beneficiary, not part of a trust, or not listing a trust as a beneficiary. If you pass away and you leave, say, a bank account that's just an individual bank account, names nobody else, either as a co-owner or a beneficiary, that is the type of an asset that would go through probate. Oftentimes, when people are married, they own assets jointly. So a lot of times bank accounts will be in the name of both spouses. So in that instance, the answer to the question, if you have a spouse, do your things have to go through probate? If they're owned jointly, they don't go through probate. They pass automatically to the surviving spouse. This is also very likely with real property. So here in Florida, if you own property with your spouse, that is a special type of property. It's called tenants by the entirety property, and it has rights of survivorship built in. So if one of the spouses passes away, the surviving spouse on the deed automatically owns the property. However, this is not always the case. Oftentimes, spouses will have individual accounts or things like individual life insurance policies, individual retirement accounts, brokerage accounts. Maybe they own some stock individually. So I always urge people to look into this to see, just because you're married, it does not mean that everything was owned jointly. And for anything that's not owned jointly, if it was just owned by the individual spouse who passed away, it will most likely need to go through probate. So it's important for any asset that's just owned individually that you do look at adding a beneficiary designation to that, one or more people, or sometimes it's a POD or a TOD. Another thing that also comes up often for me in practice is cars. Do cars go through probate? Because they are typically titled just in one spouse's name. You can have them jointly titled, but oftentimes we see they're titled in just one spouse's name. So cars are usually pretty easy to transfer to a surviving spouse outside of probate. Most of the time. Sometimes it can become more problematic when there is a loan on the car. So this is just something to think with, but usually if a vehicle is paid off, you are by law able to transfer up to 2 vehicles a person outside the probate process. Again, this assumes you are the owner of the car. When you have a loan or a lien against the car, if you're still paying it off with the bank, they're actually holding the title. So it's a little bit different in those scenarios. So it's, make sure that you actually look into these things, as part of your estate planning and figure out solutions for them in advance so that you don't have to go through probate. Now, the other thing that I want to bring up about this comment, because it specifically says, and there's no will. Under Florida law, if someone passes away without a will and they're married at the time of their passing and they have no children, or their children are adults and from that same marriage, then Florida law does say anything that would have to go through probate would go to the surviving spouse. If they have children from outside that marriage, it gets split 50-50 between the surviving spouse and all of the children. And this could be a case where they either have all of their children outside the marriage, or they do have some children outside the marriage and some children within the marriage. Everything gets split 50-50 between the kids and the surviving spouse. Lastly, I want to bring up, since this comment says, if you have a spouse and no will, do things go through probate? So I want to make it very clear to everyone out there that a will does not avoid probate. In fact, it's just the opposite. A will provides direction to the probate court as to where your assets go at the conclusion of probate. So a will by itself does not get you out of probate. And I see this all the time where people come into my office thinking because they had this last will and testament that they created 7 years ago, 10 years ago, 20 years ago, their assets don't need to go through probate. That is absolutely the opposite of what actually happens. So a will is designed to provide direction to the probate court. Tells the probate court who the executor or the personal representative, as Florida refers to it, is of that estate. It also tells the probate court where the assets go when probate is done. The only ways that you avoid probate is by either having beneficiaries, PODs, or TODs listed on everything that you own, or by creating a living trust and making sure that trust is funded. And what we mean by that is making sure your assets are actually transferred over into the trust, or alternatively list the trust as the beneficiary, or your assets are assigned to the trust. There has to be something that allows those assets to become part of that trust. So those are the ways you avoid probate, not by having a last will and testament. I hope this answers the question. I hope it helps. If there's any other questions regarding last wills and testaments or any estate planning documents, anything to do with asset protection, elder law, Medicaid, and you're in Florida, please don't hesitate to reach out to our office. We're atCAUSE Law Office, the non-stuffy attorneys, and the link is in my bio.